get a financial benefit for that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not face a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state in general rejoinder that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused person. And that leg in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. BESIGYE, one of the accused persons, was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the profession and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the KIZZA case. My senior has already alluded. I said the General Court Martial, tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that these court's hands are not tied. Actually, they are tied with chain and shackles. And I will address in broader perspective about the MOU you talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the land. And also, in the most severe, I want court to take judicial notice under the ABS Act, as taught by Senior Palibala, that even in the most cases of Jamiru Nkulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court, no. It's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified to authoritatively do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defying the Constitution of this Republic. The idea that we court covers Buruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. We desire, it's our desire, that we do not want the UPDF and its institutions, most especially the General Court Martial, to trade and train that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also do not, we are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.
Guys, subscribing, liking, and commenting.
This court, I want also to take this latitude to add on my voice as the defense team for Dr. KIZZA. It is quite very paradoxical and failures for prosecution to allege what was shown in this decision that this court has interpreted. Whereas we take legal evidence of the fact that the Constitution of the Republic of Uganda ushered in this General Court Martial to peacefully go to handle cases regarding the disciplinary benefit. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction for these questions. I would love to implore this court to adopt this decision. While the Constitutional Court was faced with the same similar matter in the case of Honorable Sam case which we had prior in the morning while submitting the same was submitted by the defense team, that is by Constable. The House of Lords in this case, while elucidating on these facts, we are able to
persuasively adopt the decision in the Namibian case of State versus Johnson, 1991, volume 20 case at Feb 813, and it was to the effect that the Constitution, this is the catching word, the Constitution of the nation is not simply a statute which mechanically defines the structures of the government and the relationship of the government and the governor. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can easily see what is happening in you. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation, the articulation of the values bounding its people and displaying its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence, they are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm different from the view of my land friends. They're trying to hoodwink and mislead this honorable court, which we don't disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that the constitutional provisions should not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the ground law. Article 2 clause 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the one which this General Court Martial is citing, if it is inconsistent, it is contrary to the provisions of Article 2 clause 2. The framers and the promulgation of that very article were alive to the fact that certain issues arising out of doing proceedings like similar might arise. That if any law, if any regulation which is inconsistent with that very particular article, it should be declared null. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court to disassociate the submission of the Constitution. They have miserably failed at any state with any item of evidence to prove their case. I so think.
Honorable Chair, honorable members, I am grateful to my son friends on the other side. Because in my view, they have not dealt with any of the issues that we raised. I'm grateful that they have made our work with. We are past the stage in this country where we should have mechanical responses to the issues. Just say no because I can say no. I should say no because it is value the position that I have adopted. I have listened carefully to what my land friends have said. A lot of it sounds to me like the arguments we will invite them to make when we go, hopefully, when they refer to the Constitution. Because those arguments will be very important in that way, as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially that the questions around impartiality have nothing to do with the 5 members who are in this court. It's not personal. We have no doubt that the gentlemen and lady officers who are at this court are fine gentlemen. But the regulations we cited, they are laws, they are not individuals. I appreciate fully the idea that the High Command and the General Marshal have different roles in the street. I read a rule that says that the High Command can consult on matters of law. I haven't heard, I think it's 69, I haven't heard the response that says it can't. If we take it to the other side where we are used to appear, there is no similar provision where a judicial officer, also appointed by the president, can consult. It doesn't seem comfortable with the idea of that. So it's an institutional issue, it's not a personal issue. It has nothing to do with gentlemen before whom and the ladies before whom. Honorable Chair, honorable members, we treasure the Constitution, as I am sure you do, because it is the only one that equalizes all of us. Only one, where everybody can look and say, I am equal to this one, in that document. So we find comfortable with some of these things that trivialize, especially where they have to do with the Constitution. This is not a petition that we are asking to be made, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my learned friends to do was to enrich the questions so that we go together and come back together better enriched, knowing where everybody can trade, so that we are not working on eggshell, nobody is working on glass, nobody is. That's what I expected. That they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology. Because that appears to us to be what must happen when Article 175B is invoked. So I would invite the Honorable Court to consider those questions as posed, and perhaps also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because there is a formal document. It will be presumptuous of us to raise the questions and then just proceed in the case. We would have been hoping that we would have agreed together with that day, so that we focus on what the court will submit. The questions that we posed were our proposals. We thought they covered the necessary ground. My brothers on the other side can enrich them. In fact, I invite them to do so. So that when they are leaving the court, we are in agreement about what those questions are. We are not debating at all the power of the appointing authority. The appointing authority appoints many people. But if an ambassador were appointed and is given, allowed to exercise judicial power, we would argue the same things. Although they were appointed by the same. If another DC attempted to exercise judicial power, are also appointed by, we would argue the same thing. We are just dealing with matters of law. They affect all of us. They are for the benefit of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly, Mylan Fred Rafael knows that constitutional interpretation is a matter in realm, it's not in persona. It is in realm. Once the court says A, it has said A. Only a superior court can unsay A. We have cited before you a number of authorities where the court which interprets the constitution has consisted. In fact, in one of the cases, we just said we adopt the other views of the past plan. Consistent. There is no other interpretation. We have one, only one. We must survive. If indeed we are subordinate to civilian authority, we must survive until there is another interpretation. So there is no stay for Semoju, there is no stay for Captain Yarugaba. I'm not sure why. That society that was referred to was confirmed. The position is clear. And I invite you, very respectfully, to appreciate that position. To do the right thing. Send us where we can set these questions. They will benefit us here in this case, they will benefit other cases, benefit in the future. We will have to. Wow. This is about all of us. Every one of us in this room. Everyone must go home comfortable in the knowledge that we know what the law says. Because again, in this jurisdiction, there is only one person who cannot be subjected to these types of processes. Only the sitting head of state. Everybody else. Everybody else, without exception. I thank you, Honorable Chair. My land friend wants to close.
Thank you, Chair. Briefly, one, the issue of Aaron KIZZA did not arise in today's proceedings. It's neither here nor there. Chair and members, the constitutional reference is not only about this rule. It's about the proceedings right from the beginning. Right from the very moment charges were read before them, and also the rulings that were made that you have jurisdiction. It's a whole package. So it's misconstruing the context of this petition, rather request for a reference, all the proceedings we have had. So that's across. The other thing is about the East African Treaty, the MOU. He made some submission here which is really disturbing, that your ruling is settled it all, that is fine. You are the alpha and omega of the interpretation of the Constitution. Is this an appellate court? That is not really the position of the law. We take exception to that, it's obvious. And it's not also an appeal to the court martial appeal court that this is an attempt to appeal. No. It's very clear, grounded under the constitutional provisions. On the question of the Supreme Court, they said there are decisions of the Supreme Court, the order of state specifically in KIZZA. I want to address you on this. 5th of August, 2021. And the decisions we made reference to of Semju and Amoni Biagava, reaffirming the KIZZA position of 2020. So, this order is not applicable. And I want us to put it in context, Mr. Chairman. I have a copy here. They are consequential orders that were given. That all files pending before the General Court Martial be transferred to the civil courts. That was the consequential order, which was still, not the interpretation. And it's the reason he advanced the argument that the decision of the Constitutional Court is in rem, is not in persona. So the consequential order is the one that was stayed. But the Constitutional Court has been consistent that the interpretation about the jurisdiction has not been overturned. If anything, it has been reinforced by the recent Supreme Court decision in the case of Ogwang versus Uganda. If I may just read one aspect of it, it's very, very important and instructive, Mr. Chairman, so that it's the only Supreme Court decision we have, the only one on this. And no misconstruction should be made to say that the Supreme Court has got any other order as far as the jurisdiction is concerned. As they are getting it for me, allow me also refer you to the submission on the applicability of the Firearms Act. Mr. Chairman and the honorable members, the same case is very, very clear. It's very, very clear. The General Court Martial's jurisdiction is only limited to trying service offences specified under the UPDF Act, only in respect to persons subject to military law. Offences under the UPDF Act. Military law under the UPDF Act must be construed to exclude laws that are the preserve of civil courts. This has not been set aside. This has not been subjected to any other interpretation. So where do they derive that argument that this honorable court is clothed with jurisdiction to handle matters under the Firearms Act? So the East African Treaty, I want to talk about the MOU and the East African Treaty. They were again misinterpreting this decision of Omar Awad. Omar Awad, the extract they were making, the extract they made is very clear. They were talking about repatriation of fugitive offenders. And when you look at the Extradition Act, the fugitive offender is defined. A person having committed an offense, you run away from the jurisdiction. And again, in this particular case, you will find the facts, you read the facts. In Tanzania, for example, where these people were repatriated from, there were extradition proceedings, only that they did not wait for their appeal. So, this East African Treaty did not in any way purport to outlaw the Extradition Act, or in any way to repeal it, let me use that word. The treaty did not repeal the Extradition Act. It is still good law, and it must be complied with. So, an MOU made under the treaty, which is also subject to question because we have not seen it, cannot be said to be within the parameters of the extradition law. Now, to emphasize the other point, Mr. Chairman, I wanted just to read that extract from one. In our view, the body of the UPDF Act specifically sets out the army courts as a parallel judicial framework, distinct and juxtaposed against the courts of judicature. It appears to have been contemplated that the UPDF courts were better placed to address the discipline issues within the rank and file of the armed soldiers, and better able to handle out penal sanctions, that hopefully deter further offending. It is through these structures that UPDF soldiers are made accountable. And they concluded by indicating that the Constitution of the Republic of Uganda, which gives Parliament authority to make such laws, as provided for under the relevant provisions, deemed it necessary to create a disciplinary court. They emphasize a disciplinary court for the members, the rank and file of the UPDF and members of the UPDF. So this reinforces the position given by the Constitutional Court that the jurisdiction of this honorable court is restricted to those matters which are within the UPDF Act and not any other. That is the latest decision in Ogwang. Now, finally, the issue of the procedure. Mr. Chairman, this issue of procedure, the procedure to follow here is very, very clear. Once you move court for the reference, the questions are raised. They are framed. The questions are framed. So we are at the stage of raising these matters for purposes of framing the questions. And this is important. So I don't know how else they wanted this to be done. And this has been the practice all through, that you raise the questions, you raise issues, and then the questions are framed. So they can't fraud us on the procedure we have adopted. Allow me to invite the Council Fred to add one or two submissions.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to be quick because it's been a long day.
Subscribe.
My colleague, Colonel Raphael, I hope that's correct,
Extreme
make
media.
reference to similar provisions in the Penal Code and the Act regarding terrorism. I just wish to remind him, Mr. Chairman, that none of the offenses in the charge sheet and the amended charge sheet for that matter are brought under the Penal Code of the Act regarding terrorism. So that attempt to juxtapose it cannot really hold. The other one, he did refer to the appointment of the lady and gentlemen officers of the school. court and saying that they are also appointed by the Fountain of Honor. It is correct. Just to remind the court that when the judges and justices have been appointed, because they do perform a function of determining rights and obligations, including determining whether someone should leave or not, there is an extended process which starts right from running adverts in the newspapers, whereby the public speaks. Mr. Chairman, we are not aware of any such similar process of an advert regarding the membership of the court martial. We are also not aware that the most junior and this officer of the Uganda Defense Forces perhaps engages in the process that appointed the ladies and gentlemen officers before us. We want to assume that that is at the pleasure of the Fountain of Honor, perhaps having communion of the members of the High Command. And that is why, as my young friend alluded to, that Regulation 69 envisages the good manners that you revert to your appointing officers. The challenge there is, Mr. Chairman, is that it wouldn't be about budgeting or the logistics, as our friend tried to say. It actually says you refer to a point of law. Mr. Chairman, matters regarding life and death are matters of law, because the Constitution dictates that one shall only be deprived of life by a decision of the court of law. So my submission is that by removing that function and causing you to make reference to a body which is not here to hear the evidence, to determine, to see the demeanor, to see the veracity of evidence, is to undermine the impartiality. And to that extent, I will add that while my young colleague gracefully and passionately and professionally referred to what he was told by Mr. KIZZA, I am alive to the fact that he did not teach him that one. But it's over time, so perhaps there is a slip of mind. Mr. Chairman, the other one was in regard to the MOU. Mr. Lupago, Council of Senior Police, did refer to the fact that we have not seen it. It is not, even where we don't have a hard copy, perhaps Council should have been gracious to say it is dated today, it was signed here, and signed by these people. Because the Constitution, Mr. Chairman, in Article 123, reads, the President or a person authorized by the President may make treaties, conventions, agreements, and other arrangements between Uganda and any other country, or between Uganda and any other international organization or body in respect to any matter. The second sub-article is that Parliament shall make laws to govern ratification of treaties, conventions, agreements, and other arrangements made under Clause 1. It means that an agreement, which would be an MOU, which has not been ratified, cannot be or operate as a law, as our colleague tried to put. It was therefore, my Lord, Mr. Chairman, Section 4 of the Treaty of the Act which deals with ratification of treaties says that all treaties ratified by Cabinet shall be laid before Parliament as soon as possible. So to the extent that the procedure commanded by the Constitution was followed, our colleague shouldn't have been referring an MOU. It should have been referring to an act which was laid before Parliament, which arose from a ratified MOU. So to the extent that we are looking at an agreement, Mr. Chairman, I don't want to assume that my colleague would agree that as it happened to the accused persons, A2 and A3, that if that fate befell him in the general court martial in Kakamega in Nairobi, he would argue that I am here properly because of an MOA I have received. So we request that, again, the right thing is done. We cannot, based on an argument, to determine rights and movement of people, as Article 123 commands. Lastly, Mr. Chairman, is the prosecution team, heavily led by Colonel Raphael, did, in their view, read the questions we proposed and the provisions of the law, and in their view found that there was nothing to interpret. Mr. Chairman, the point we are making is that the interpretation we are seeking is not the meaning of the words in the statute. That's not the interpretation. Under Article 137, 5B. The spirit of that article is that it envisages a state of affairs such as now, which could be an act as action of a law, but which must be put into perspective or juxtaposed with the supreme law, which is the Constitution, to see if it complies with the basic requirements of the Constitution. So it is correct that when we read those sections, we understand what they say. We are only saying that to the extent that we understand them the same way as they do, those brought so or should be brought within the perspective of the Constitution to determine whether they may contravene the rights of the accused persons. It's not the ordinary meaning. So we do request, and I have seen, Mr. Chairman, that our colleagues do not quite disagree with the way those questions were framed. As my colleagues have said, that's what was expected, that's what the law envisages. As my colleague read the rules, that once the questions have been raised, the role of the court is to frame those issues and forward them in the manner provided by the annexure. 8 copies. To the extent that they don't disagree with the issues as framed, our request that the necessary results should follow, that the questions as framed, which they appreciate, be forwarded to the higher court for interpretation, just so that when we come here, we don't bog this court down with objections, because then everything shall be in a clear perspective. We thank you for listening to us.
Subscribe, like, comment, and share the link. You are watching Extreme Media UK. Subscribe, you are over 400. Why don't you like the video? Listen carefully. Subscribing, and you like the video. Manange bibasuse enkola babe kuba amaaso. Look, be careful about subscribing, liking, and commenting. You share the link, share. That's how you know. Anytime from now. The court have been adjourned for 1 hour.
To rule on all issues raised.
Guys, the court have been adjourned for 1 hour. Guys, the court have been adjourned for 1 hour. Guys, send me some money. Extreme Media UK. The court have been adjourned for 1 hour. I feel there is progress. Sawa zili kumi. n'eddakiika 19 tetumanyi nga the court have been adjourned for 1 hour. Subscribing, liking, commenting, and you are watching Extreme Media. Jogeza Nicholas Keke, video Nicholas is my name. Guys, alinayo ka data kati exciting kubanga tukyali wano naye ndaba sirina data wano data alinga agenda okuzibwako. So subscribing, liking, commenting, kyolina omwanya ekooti bagyongezaayo. It has been adjourned for 1 hour. Alright. Leero luno olwaleero luno chika kitokota tuli bwema negereddekebedde ekintu ekiri mukumbulamu kiri kimu ensonga ya data ya data naye nga you are watching Extreme Media UD. Amazimako ekooti bagyongezaayo. It has been adjourned for an hour. For an hour. Sawa ziri 10 n'eddakiika 2 okukomerawo. Guys, the court have been adjourned for an hour. Labayo okusongaganamu oluka wano. Labayo. BC. Guys, subscribe, commenting. Leero luno okunda kufa dala walkout dawalabira wano Extreme